For this hearing is available on Judge Mallard's YouTube channel. That's me at https://coi.isc.idaho.gov. You'll also notice that some of us are wearing masks and some of us are not. I'm in a courtroom alone by myself, so I'm not wearing a mask. Because Ms. Daybell, Mr. Means are sitting at a table together, they are wearing masks. Mr. Means, can you describe for me who else is in the courtroom with you?
I can, Your Honor. Obviously, myself and my client, Mrs. Daybell, and we have 2 deputies from the Madison County Sheriff's Department present as well.
Thank you. Mr. Wood, is anyone else there in the room with you that we can't see inside the frame?
No, Your Honor.
All right. Then today is the date and time set for a pretrial conference, and the purpose of a pretrial conference is to set a jury trial date and other necessary dates. It's also to discuss matters we need to take up to make sure we have an orderly disposition of this case. Since the last hearing, Mr. Wood has dismissed the felony counts relative to this case here in Madison County, leaving the 3 misdemeanors at issue. Count 1, resisting and obstructing. Count 2, solicitation of Melanie Gibb to resist and obstruct. And count 3, contempt. Mr. Means has filed a not guilty plea to those charges, a demand for a jury trial, which means we need to set this for a jury trial, and a number of other motions that I will discuss here in a few minutes. So that is all that we are prepared to take up today. As I noted, Mr. Means filed a couple of other motions that may need to be scheduled, one for sure, the others I'm not quite so sure about. But the first thing that I want to go through today is setting the jury trial. Mr. Means, can you tell me how many days you think you will need for a jury trial?
Well, I'd be interested to hear how many days the prosecution thinks as well, but I think we would need to set this for approximately 4 to 5 days for these misdemeanors, just to make sure we're covering our bases. It could potentially be longer. I mean, obviously this case is a little different than most misdemeanor cases. So there could be some other time issues as far as in preparation for the jury trial that might add a few more days to that number.
All right, Mr. Wood, tell me your view of how many days. And I realize there are other charges outstanding in Fremont County that you are also the prosecutor on. So if you could just let us know what your plans are in regards to this jury trial.
Your Honor, in terms of time, I agree with Mr. Means. Approximately 4 or 5 days would probably suffice. And so, yeah, 4 or 5 days, I think. We probably should just block off a week at some point to do it.
All right. Okay. And Mr. Means, tell me how long you think you need to prepare, how long you'll need between now and the jury trial setting.
I think probably more than your traditional setting. We have some discovery that's going to come over in the next few days. I understand it's another extensive amount as far as size goes, as gigabytes and information and whatnot. This case obviously is a little different than most. I would be reluctant to say anything within the next 6 months, really. There's a lot of conversations that prosecution and I need to have regarding this. My client is, if I can inform the court, is going to waive her right to a speedy trial on this matter, if that helps with the scheduling as well.
Mr. Wood, your view of how long you need to prepare?
Your Honor, on this case, the state doesn't need that much more time to prepare. However, as to what Mr. Means said, there are conversations between the defense and the state in regards to venue, possible consolidation of cases. And so In and of itself, no, we don't need a lot of time to prepare, but I think what Mr. Means has said is accurate in terms of the conversations we're going to be having in terms of when we actually try this and if it gets consolidated with other charges.
All right. Well, 6 months out takes us into January. Is that what you're thinking, Mr. Wood?
That's fine with the state, Your Honor.
Mr. Means?
It's fine with me, Your Honor.
And I do not have in my courtroom a calendar that extends into January. Madam Clerk, can you let us know what the third and fourth Mondays in January are?
Yes, I will.
If I can, Your Honor, according to my calendar, January 18th of this next year is going to be a federal holiday. So
Okay.
we might be looking at the fourth Monday in January if we want to try.
And what day? What day is that, Mr. Means?
Martin Luther King Day.
Right. Yeah. Thank you for calling that to my attention. But the next Monday, what's the next Monday?
I don't see any conflicting holiday on the 25th.
Okay.
It would be the 25th to the 29th.
Okay. Mr. Wood, how does that work for you?
That's fine for the state, Your Honor.
So we'll set the jury trial for January 25th through 29th. Plan on starting at 9 a.m. And we'll, I mean, right now it's set for Madison County. I understand that Mr. Means has reserved his right to request a change of venue. The next thing that I want to take up is scheduling Mr. Means' motion for a bond reduction. Have the two of you discussed that at all, Mr. Wood?
Yes, and the state is fine if Mr. Means wants to argue that today. We're prepared to argue that. Obviously at the discretion of the court, but we're fine to argue that if he wants to today.
All right, Mr. Means, is that what you'd like to do, is talk about it today?
If that's possible, Your Honor. I don't think a lot has changed since the last two bond hearings we've had. So I think it's pretty short and concise as far as our argument goes on why it should be reduced.
All right. Well, the court was not prepared to take that up today. Let me ask Madam Clerk to put us all in the waiting room for just a minute. Let me take a brief recess. I will get my notes from the last hearing so that we can not have to start from scratch.
So we're going to go into a quick recess. I'll bring us back up when they come back up. Let me share this quick. Well, you're not going to miss anything. We're just here in this recess. But once they come back in, I'll kick it back in. So she waived her right to a speedy trial. What that means is they really can put this trial out even further. I would doubt that the trial is going to happen at the first little catch of when they put this date in. So I would much more say it's more realistic they're going to push it out a couple more times, and then they will kick it back into a later date in 2021. The waiving of the speedy trial is a formality. Here we go. We're going to kick back in right now after their quick recess. I'm having to rip this from another YouTube because they haven't posted this live yet.
Everyone back in place. Can you hear me okay, Mr. Means?
Perfect. They're back.
We can, Your Honor. Can you hear us okay?
Yes, Mr. Means, since this is your motion, go ahead with your argument.
Okay, thank you, Your Honor. Real short, Your Honor, as set forth in our motion, the change in circumstances here really is regarding the dismissal of the 2 felony counts that were in the previous complaint. We're left with, as the court mentioned earlier, 3 misdemeanors, an obstruction, a solicitation, and a contempt charge, which carries with it a maximum, according to my calculations, 2 years and possible $2,500 fine. The only thing I would add, in addition to the things that have been argued in the previous 2 bond hearings, is my client has been a model inmate. These charges are not of a violent nature. There is no previous criminal record regarding my client in any other jurisdiction that we're aware of. Her access to funds is extremely limited. I think the court has issued an order previously outlining that if my client were bailed out or bonded out, that there were certain restrictions in place that we're fine with keeping those restrictions. We think ultimately that the $1 million bond isn't reflective of the current charges, that we'd ask that the court reduce it to $100,000.
Mr. Wood?
Thank you, Your Honor. We do acknowledge that at this time, the defendant faces misdemeanor charges in Madison County. We also acknowledge that she's also being held on a $1 million bail in Fremont County. We would point out that each of these misdemeanors were, in the state's view, an overt act of in furtherance of a felony to conceal the location of the defendant's minor children, Tylee Ryan and JJ Vallow, who are deceased. In terms of the factors in Rule 46, I'll just focus on what we see has changed from the last time we argued this in front of Judge Edens and in front of yourself. And I think where it's really changed, well, one is her familial, any family contact she might have. Her only family contact is Chad Daybell, who is a co-defendant in the Fremont County case. And in our view, her only family contact now is someone with whom her legal interests are completely adverse. In terms of aggravating factors, I think that's where the real change has occurred. There are many aggravating factors. I'd point out that, Your Honor, the last time we had a discussion of bail in this case, we were arguing about jail phone calls while the defendant's children were dead. And the state finds that very troubling. And so I just point out, Your Honor, that when the defendant obstructed the investigation into the safety and welfare of JJ Vallow, she was hiding the location of her dead child. When she attempted to get Melanie Gibb to lie to the police on her behalf, she was attempting to get Miss Gibb to lie about the location of her dead child. And when she refused to comply with a lawful order to produce her children, she did so in an effort to conceal the deaths of her minor children, all while telling family and friends that they were fine. And so, Your Honor, those aggravating factors that bear on the likelihood of conviction are troubling, they're strong, and quite frankly, they also bear on the defendant's character, which the court is allowed to consider in a bail reduction hearing. Acknowledging these charges are misdemeanors, if the court is so inclined to lower bail, we'd ask that it be no lower than $250,000, and we would ask that all the current restrictions on bail and her release remain in place.
All right, thank you. Anything in response, Mr. Means?
Just briefly, Your Honor, obviously the court is well aware that the client is innocent until proven otherwise. I think some of the argument that has been put forward to justify a $250,000 bail is based on, though out of respect for the argument, speculation. that requires a certain amount of jumping from point to point in order to justify. Again, we just ask that the court consider the dismissal of the felony charges, which were previously the bulk of the potential incarceration time. Here, we're looking at 3 misdemeanors, and I think $100,000 is more than appropriate in this setting.
All right, thank you.
Thank you, Your Honor.
There are 2 procedural matters in this case that are inescapable. One is that these are misdemeanors with a total maximum sentence of 2 years if they're run consecutive to each other and if Ms. Daybell is convicted. The second procedural matter that impacts my decision is that there is another pending case in Fremont County, case number CR 22-20-838, a conspiracy case again, there's conspiracy case against Ms. Daybell. And that case has a $1 million bond. So regardless of what I do with bond here today, there's still another case with a $1 million bond that is outstanding. I'll note that Ms. Daybell was taken into custody in February of 2020. So she's served at least 5 months by now, which if she were convicted would go as credit to her sentence. I've previously noted that the factors that I consider are those stated in Idaho Code Section 19-2904 and Idaho Criminal Rule 46C. We really are not going to have any trouble, I don't think, ensuring the appearance of the defendant, no matter what bond I set, considering the bond in the Fremont County case. Bond is present. She does have the right to bond, and I will set bail today and will lower it. A third prong is ensuring the protection of victims and witnesses, and the fourth is ensuring public safety. I cannot overlook Idaho Criminal Rule 46C, subsection 6, which is the nature of the current charge, which I've already taken into account. They're misdemeanors with a relatively low maximum sentence. But also that prong requires me to take into account any mitigating or aggravating factors that may bear on the likelihood of conviction and the possible penalty. Of course, in our system of justice, Ms. Daybell is considered innocent until proven guilty, but every court in Idaho, in consideration of what bond should be set, is allowed to consider the likelihood of conviction and any mitigating or aggravating factors that may bear on that likelihood. I think it's inescapable that these misdemeanor charges are relating to the whereabouts of her minor children who have now been found deceased. All of the other factors are really no different than where they were when we had this last hearing. I am going to reduce bond based on my consideration of all those factors. I'm going to set bond at $50,000 on each count for a total of $150,000 in bond. If Ms. Daybell does post bond, I'm adding an additional condition to her release that she have no contact whatsoever with her alleged co-conspirators. In the Fremont County case number CR 22-20-838. Do you have any questions or clarifications about my decision, Mr. Means?
I do not, Your Honor.
Mr. Wood?
No, thank you, Your Honor.
All right, the court will prepare the amended order regarding conditions. Mr. Wood, would you prepare the order regarding the reduction in bond?
Yes.
All right, I'll anticipate seeing that in the next couple of days. Anything else we need to take up at this pretrial conference, Mr. Means?
I don't think so.
Mr. Wood, anything else we need to take up?
No, thank you, Your Honor.
I'll remind both attorneys to pay close attention to the pretrial order I will issue within the next day or two. It will have the required deadlines, and you will be expected to either meet those deadlines or to ask for leave to depart from those deadlines. We'll be in recess.
All right. Well, they just finished that pretrial. That was yesterday. Actually, it wasn't today. You weren't watching it live. Sorry, guys. I was fishing or something. They reduced her bond, but you got to understand. I hope the judge was clear in what you understood that she now has $150,000 total in bonds on the charges she's being held on in, I think it's Madison County. In Fremont County, she still has $1 million bond. So even if she were to come up with $150,000 cash, give it to the county she's in, they would actually hold her in jail until Fremont County came and got her, where she's held on another $1 million bond. She's not getting out of jail. The reason the judge did this is because if and when she goes to trial on these charges, the judge does not want her bail and bond to look bad on her as a innocent until proven guilty thing. So the judge can reduce her bond as much as she wants, knowing full well she's not getting out of jail. It looks good that the judge is keeping it legal and not biased, and that she's being held and being treated fairly. You know, if on an appeal she wanted to say, well, listen, they treated me unfairly from the start. They put me on $1 million bond on a very low misdemeanor charge. Now, that doesn't mean more charges aren't coming down the pipe. Prosecutors are not in a hurry, all right? She's going to sit in a box until trial, which is now set for January, which I think will be set out even farther, but we're looking at January 2021. So what happens next? Okay, they've reduced her bond. This is the pre-trial hearing. She's pled not guilty. They've set a jury trial. They're going to go through an evidence hearing. They're going to go through a probable cause hearing. They're going to go through now jury selection, and they're even already talking a change of venue. So there is a possibility that we find it, that they go into a change of venue. If they go into a change of venue, I can guarantee you the trial's not going to be in July 2021. They will go into a change of venue, then they'll reset a trial date in a different venue. And listen, very likely, very, very likely that they could grant a change of venue, because all the while Lori has been setting up this narrative They've been recording my phone calls. I'm not getting a fair. So all she has to do is prove that there's some bias amongst the community and county, or biased amongst getting a fair trial. And she, most likely, a judge is not going to risk a mistrial just because they won't grant a change of venue. It has very little to do sometimes with actual jury selection, although they can put it out to asking for a trial change, at least in the state of Colorado. I don't know what the state of Idaho allows, but the state of Colorado allows prosecutors to ask for a change of venue even up to the first jury selection. So we might not get that change of venue request or motion up until after they find out maybe they can't get a fair jury, or they feel like there's a fair, not a fair and impartial jury. So no matter where it goes, it'll be interesting to see what happens over the next couple of months. She got a reduced bail. She's not getting out. They're not even going to deal with those other charges. They won't even deal with that other county until this one's over. So she could very well sit in jail. Let's say she sits in jail all the way up to her trial. Let's say by some miraculous work of defense, she gets found innocent, or they dismiss the charges here in Madison. All of a sudden, immediately, she's transferred to Fremont and she's held on conspiracy charges. And so, which are felony charges, because they're conspiracy to commit murder, maybe in some things. And so, who knows what's going to happen with Lori Vallow and Chad Daybell? What I can probably say with good confidence, the rest of her days will be spent in an iron box or brick box somewhere in the Idaho Correctional Facility. It doesn't look like she's getting out anytime soon. They're going to begin to stack charges on her. I thought the prosecutor might just add some charges in this hearing just because he can. But now he has her right where he wants her. He got her to waive. Time does nothing but help the prosecutors. He got her to waive the right to a speedy trial, which means now he can take all the time he wants, and it has very little now. When she does not get to determine when she goes to trial. Now that she's waived the right, that it really is now determined by the prosecutors, because they can continually come back and say, we're not ready, we're working on something here, we're looking. She's already waived her right to a speedy trial this early in the game. And so he's good to take his time, prepare a good, excellent case, vet all the witnesses, depose all the witnesses, get a good understanding of who could mess this thing up, who couldn't mess this up, who has more information. Someone will come forward maybe with more information now. And so that waive your right to a speedy trial only works in benefit for the prosecutors. Very seldom is that beneficial for the defendant. And most likely in this publicized case, people are not just going to forget about it. The news isn't just East Idaho news. Oh, Nate is not just going to disappear. He's going to be coming and continuing to bring updates. So it'll be interesting to find out, but it does work in the prosecuting attorney's favor. So this one's a time game now. Now we'll see what old Chad Daybell, the co-conspirator, the counterpart, as the judge called him. Let's see what he does at his trial hearing in the next couple of days. Talk to you later. Thanks for following Dad with a Phone. Make sure to hit that like and subscribe button. My little daughter's looking at me right now. My little girl that's growing up so quickly. Anyway, I'm out of here. We'll see you. Oh, did you stick around for the PS? I just read someone's question. When is July 22nd? That's like tomorrow? We should do a special Chad Daybell July 22nd live video, the day the world ends, according to Chad Daybell. So this guy wrote whole books on that July 22nd, the world is going to end. So Wednesday, July 22nd, according to Chad Daybell, the world is going to end.
On Wednesday.
You have something planned on Wednesday? According to Chad Daybell, you might not be able. It might not happen. So July 22nd, Chad Daybell has predicted the world's going to come. Chad Daybell, Chad Daybell has predicted that the world's going to come to an end. Buddy, your world has come to an end. You were early. I told you this last month. Your literal world is now an iron box, probably for the rest of your days. You predicted it. You predicted it. So good on you, man. Write a new book. How you metaphorically predicted the end of your own life. You should write a new book on that, man. The end of the world for Chad Daybell happened last month. He says it's going to happen July 22nd, which is in a couple of days. Maybe I'll never be back after that day. Maybe the end of the internet will happen. Why will you be okay if the end of the world happens? You wouldn't be sad about it? It would just be the end. It's the end of the world as we know it. It's the end of the world as
Are
we
you on video right now?
know it.
Oh, Lord.
That's creepy, she says. My daughter says she would not be unhappy if the end of the world happened.
Woo, the end of the world's happening. I would be like,
I need a second camera right now from Miss Ella.
who?
Isley.
Do
Isley.
you have 2 daughters?
I do have 2 daughters. Isley. I'm talking to Isley, not Ella. Talking to my oldest daughter. All right, I'm out. Thanks for watching Dad with a Phone. I hope you stuck around for the bonus material.